Welcome to Cordell Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, it's Scott Trout, Managing Partner, CEO of Cordell Cordell, and welcome back to the Men's Divorce Podcast. And today we're going to talk about the word that we tend to, as lawyers, we throw around a lot of legalese. We throw around these terms and we just, presume, like doctors or engineers or accountants, that everybody knows what we're talking about. It's discovery. And you think about the word in and of itself, what it would mean. We're trying to discover things, but it's a tool that we lawyers use for your benefit. And today we're joined by Igers up in Kansas City. Welcome.
Thank you, Scott. Good morning. Thank you for having me.
Yeah, great. So let's talk about it. Discovery is an essential, important tool. And let's talk about why. Why should clients, why should anyone going through any family law issue consider discovery? And we'll get through the types of discovery, but why should they consider it?
So discovery is what I call the heart of a case. A lot of clients that come through our doors, they think that I know my spouse or my significant other, and we don't have anything to discover. And the next thing they know is there's a bank account they did not know about. There is a security box they did not know about. There is an account that they are a beneficiary that they've been stuffing with money throughout the years of the marriage that they did not know about because it's in another person's name. And when we do discovery and are able to find this stuff, it just leaves these clients in shock.
Yeah.
And the other thing why discovery is important is you don't want to go to a trial by ambush. Discovery is not just about financials. It's about custody. It's about parenting time. It's about allegations of neglect, of abuse. If you don't make these questions, which the other person has to answer under oath, then you're going to go to a trial of unknown and face this for the first time, which most likely is going to hurt your case.
Yeah.
So we will tailor the discovery to understand what are the allegations that the other side will make against our client over custody and parenting time, over why they shouldn't have joint legal custody, equal parenting time, and so forth. So it helps us to better prepare and do maybe a second round of discovery, maybe do a deposition, maybe bring an expert in to help our client's case.
And I oftentimes, when we talk about family law, the relationship with clients and lawyers, I liken it to the medical profession. And as you were talking about kind of discovering things and what's out there, it's like exploratory surgery. You have some doctors who say, look, I don't know what's going on, but we need to figure out, we're just going to do some exploratory surgery. And they're trying to avoid the unexpected. If they think, oh, it's this, but they need to go find it. And then they determine a course of action. It's very similar in the law, is that we may surmise there are issues in the bank account, or we may surmise that someone's making more than what they claim that they're making. And it's an exploratory action, but designed just like a doctor would to protect you, for your benefit, to make sure we can put together a strategic plan to achieve the goals, or try to get as close to achieving those goals as we can. And so in the law, this discovery, as you say, we don't want to be ambushed at trial, allows your lawyer and us to do certain things with specific mechanisms in a case. So let's talk about those. What would we typically see? And I know I've thrown these terms around. What would clients expect in terms of discovery? What kind of mechanisms would they use?
So depending on the jurisdiction you are, we'd first start with a first round of discovery. And depending on the issues on the case as well, this first round of discovery would cover financials, would cover history of the case, involvement of each parent in the life of the children, involvement of each parent in the day-to-day taking care of the house, or in anything in between, which go to, or might go to the core issues of the case, which is, again, the division of assets and debts, the spousal maintenance, the legal custody, parenting time, and child support.
Yeah.
And then through this first round of discovery, we'll ask questions under oath where the other side will have an obligation to tell the truth. And we'll ask requests for production of documents to get these documents. Yeah. And in that way, we have now what we call the first round of discovery completed, to then determine whether we need a second one, or whether we need to dig into what we find in this first round.
Yeah. And, many clients will say, well, why do I need to spend the money? I already know what she's going to say, kind of thing. And that's why, to me, interrogatories and requests for production of documents, these interrogatories are a series of questions. And as you say, every jurisdiction has different rules, limitations, procedures, like here in St. Louis County, the petitioner, the plaintiff, has to answer the questions first. The same questions you're going to ask of your spouse, you have to answer them. And there's a set number of questions that you can do, but they're so critical to understand and frame the issues. For example, I was talking to a client yesterday about custody. And I said, well, what's the worst thing she's going to say about you? Well, an interrogatory, we would ask, why shouldn't the father have, 50-50 custody? Why shouldn't he have legal custody? Why shouldn't he have equal decision-making authority? We want to set that stage, as you suggest, to perhaps open the door for a second round, which some jurisdictions allow you to ask a second set of questions or production of documents. It's like maybe a treasure map. One clue leads to the next, and you keep going, right?
Yes.
Yeah.
One of the most common things I hear, which you said earlier, that why do I need to ask this? Because I know what she's going to say or what he's going to say, and I know what's out there. And when we do then these rounds of discovery, and then we receive allegations of physical abuse, receive allegations of child neglect, then our clients will get shocked and say, what happened? This is not true. But then that helps us to then dig in more into that and get more facts and get more evidence that we can then prove that that's not true or work with those allegations and best prepare our client's defense and case moving forward.
Absolutely. It's the age old, I'm sure if a client's gone through this process, lawyers never want to get to trial and not know the answer to certain questions. Inevitably, something new will come up, but we want to minimize the amount of information, the amount of evidence, and really the story they're telling. We want to know it all so we can prepare. And that's just what, to me, all of the elements of discovery are critical. They're really not an option for my clients. I tell them and explain to them why it's critical, how it will save them money in the long run and reduce their risk. And that's really those types of things that you have to do in family law. It allows you to decide along the route whether or not it is a case that we should settle, a case we should try, whatever it may be. Which leads us into the idea that a lot of clients come to the office and they'll say, look, I've got all my bank statements, I've got all of her wage information, and they don't understand necessarily, why can't I just use that? Why can't I just offer that to the court? Well, there's all kinds of authenticity rules. And so we can send subpoenas, right, to get official documents if the other side won't agree or stipulate that they are authentic. So we can send subpoenas. So explain what those are.
So it's interesting you mentioned that. One of the most shocking discoveries that I've had to encounter dozens of times is when we have a client that alleges to have a bank account or few bank accounts on the same bank. And those bank accounts have been joined throughout the marriage. And they are 110% certain that there is no other accounts out there. There is no other financial accounts or money hidden somewhere else. And but there is sometimes transactions that can raise a red flag, right? Maybe a transfer, maybe a large withdrawal. And oftentimes, as sometimes crazy as it sounds, it goes unnoticed from the other spouse, because not every spouse will check the bank statements every single month to see every single transaction, right? Mm-hmm. And oftentimes we would send a subpoena to the bank, which will require bank to formally produce bank records for both of these spouses that they have in their system for a certain amount of years, depending on the length of time that we requested. And they have to provide those documents along with a business records affidavit, which helps to authenticate and then enter those records into evidence later on at trial. And more often than not, and to our client's shock, you'll find that now their spouse, that they've been married for 10, 15, 20, 30 years sometimes, has had a separate bank account on the same bank for a very long time, and sometimes stuck with 20 grand, 30 grand, 50 grand.
Yeah,
and they leave them in shock. And that's where I then talk to my clients and say, this is the power of discovery. Otherwise, you wouldn't have known this. Otherwise, you would have finalized a divorce decree that seemed fair and equitable, but which was not, had it not been for this formal discovery request,
Right.
which in this case would be the subpoena.
And that's why they hire us, for the very purpose of finding all the assets and the debts, and then being able to present some recommendations so that they can make informed, intelligent decisions on whether or not that settlement is reasonable, what they should be requesting at trial. And it is so important, as you point out, that you think you know your spouse until you realize you didn't. And not that every marriage has nefarious or interesting behaviors like that, but it is really a reasonably priced, where you don't have to spend a lot of effort to do it, just to make sure we know we have actual information, which then leads us into medical issues. So sometimes there are medical records that need to be obtained. The only way to do that is through a subpoena to ensure that it is something that could be admissible in a court system, right?
Correct.
Yeah.
And we deal with that a lot on cases where we're dealing with a mental health issue.
Mm-hmm.
In case of either a client or an opposing party, we deal that in cases where the child has certain medical issues that we're trying to get those records. Are oftentimes either agreeable by the parties, or you can request it through the court. You will depose the other side, whether that would be the opposing party in your case. We can be a lay third-party witness, or you can be an expert witness, where you would ask questions under oath with a court reporter about the case. And the beauty of depositions is that in discovery, for example, in the formal discovery, the other party responding will have all the time in the world within that 30 days time frame to respond, think about the answers, maybe polish them, maybe clarify them. However, in a deposition, they will not have that time. And while they might think that we might be asking the same questions, oftentimes we don't, because that's how we build our case. And oftentimes you'll catch the other person off guard and get the information we need. Yeah.
I mean, depositions for me, I never try. Every lawyer is a little bit different in what their approach on the deposition. For me, it's not a mechanism to win the case. It is to prepare me so that I know everything that the opposing side is going to say. Everything. I want to know their strategy. I want to know the good, the bad, the ugly, and so I can prepare my client. I can prepare for perhaps contravening evidence, so I can attack their position. So I can show that perhaps the spouse is lying. And then I can expose that, because credibility comes into issue in depositions on a number of ways, whether it's spousal maintenance, custody, property division, debts, whatever it may be. It's so critical. And those include depositions of third parties, lay witnesses, people that have witnessed perhaps events that they're talking about, those are so critical. It's not just resigned to the clients or the parties, right?
Yes. The best part of the deposition is that it accompanies the formal discovery. Mm-hmm. And it's your other chance to keep a lot of evidence out that otherwise the other side will try to catch you off guard at trial. And it has happened to me numerous times where I've done discovery and then I've done a deposition, and I've specifically asked and tackled, serious questions based on the allegations made against our clients. And I've got the answers that I wanted. And then at trial, the witness has changed their testimony, at which point I've been able to impeach them, attack their credibility, and throw out the evidence they were trying to introduce for the first time after they were given multiple opportunities under oath to provide that evidence.
Yeah.
And that's what I tell our clients, that this is why discovery is important. This is why deposition is important. Otherwise, we would have heard this for the first time, and the judge would have heard it for the first time, and we wouldn't have anything to either back it up or attack it.
There are many lawyers in my years of practice who just don't do it. And they say, oh, it's too expensive. We can handle this. I know everything that's out there. And, I'm always trying to find examples. And I think, okay, maybe it's the difference between when I have these conversations about the cost benefit of discovery and depositions. It's, I can install laminate flooring in my house, and I know that I'm probably going to have to replace that in 10 years. Or I can install luxury vinyl plank flooring, and I'm going to go 30 years. And so I think about it, I have to replace the laminate every 10. I'm going to have to replace it 3 times before I replace the luxury vinyl plank flooring. And I have to look at that cost. I mean, if the cost is only 1.5 times, of course I'm going to spend the money. And you look at, what am I going to get? So I think what I'm telling you as you're listening, is the clients and those going through this, is ask your lawyer, what are the benefits here? What do I gain from it? And then what does it cost me? And we can kind of give you general ideas of what discovery will cost. And a deposition maybe a half a day in preparation. And I can sell a client and say, this is why it's so important and why I'm going to be better at trial for you, and whether you're going to be more informed. And I think you probably share the same thoughts.
So, the difference in discovery is that, or if you don't do discovery and then go to a case and conclude the case, is that unlike the changing the floors in 10 years, you can't really undo what's done here anymore.
Yeah.
In mostly every case. I had a specific case where the opposing party was claiming that they were making the state's minimum wage. Mm-hmm. They were working part-time, they were working cash, and through the initial hearing on the jurisdiction I was practicing, it goes through a hearing officer first before it goes to the judge. They were taking everything as true. Yeah. So the child support on that scenario that they were calculating was based on $7.25 an hour.
Wow.
Times 40, which made a huge impact compared to the evidence we were able to find through a formal discovery and then a deposition, to come to find out that the opposing party was making over $60,000
wow.
in cash receipts that was being deposited on various bank accounts that we were able to get through a discovery request, as well as through subpoena, because again, they were not produced in full.
It's so valuable, and it's our job. I mean, this is, otherwise, you just hire somebody that just walks through, and the steps that are so easy. And you hire us to be analysts, you hire us to kind of find and be treasure hunters and treasure seekers, and find information that otherwise we couldn't get. And not always we can find something, but at least we explore the opportunities. And I think that's why discovery is so important. So thanks for joining today, Igers. It's a lot of things that people have questions about, so I appreciate it.
Well, thank you for having me, Scott.
So ask your attorney questions. That's really what it's all about. And I think that's what these podcast series has been all about, is to stimulate a conversation between you and your attorney who practices exclusively in family law like we do at Cordell Cordell. It really is worth it in talking through, what can I do? What are my options? And then you choose when being fully aware of all of the things that are set before you. So if you haven't subscribed to our podcast, do it. You're going to get alerted. You can go to iTunes and subscribe. And if you haven't joined our Men's Divorce Podcast live version, we do that once every month where we're live, and you can log in, ask questions of a panel of attorneys, and get answers right then and right there. It's free. All you have to do is register. You can go to our social media. You can go to CordellCordell.com. You can check us out, but also check out our YouTube channel. It's full of information as well. And if you want to hear more information, you want a consultation, you can go to Cordell Cordell. and click, and you can schedule right there without picking up the phone. You can find out availability. You can find out where the closest office is to you and go ahead and schedule that appointment. That's the only way to get legal advice is through a consultation. So until next time, have a great week.